Good afternoon. My name is Alina Shevtsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you about adjustment of status based on marriage if you here on, let's say, F1, B1, or J1 status. Okay. I receive many inquiries from people who are worried what's going to happen to them if they marry a U.S. citizen and they're under the contract on according to one of those visas, and if they lose that status, will they be able to get a green card in the United States? So the way it works is like that. For example, there is somebody who comes here on H-1B contract or J-1 contract, and the contract says you promise that you will not marry anybody. If you do marry somebody while you're in the United States, we will terminate your status and you will have to leave the United States immediately, right? Because in many of such situations, it's not only what you do that may cause termination of your status, but also what your sponsor does. Let's say sponsor does not like something and they withdraw the petition for you, or they will terminate your service record, and then you're out of status, right? But here are the things that you need to know about marrying a U.S. citizen in the United States and adjusting status based on that marriage. The United States laws, immigration laws, specifically forgive those who are spouses or immediate relatives of the United States citizens and are applying for adjustment of status. They specifically forgive for two immigration violations, such as unlawful presence, meaning you don't have status in the United States, and unauthorized employment. What does it mean? It means, let me give you an example. Let's say you are on F1 status, right? And you spoke to your school DCO, designated school official, and you said, listen, I'm going to getting married. And they say, oh no, you cannot get married here. No, because we will close your status. You cannot do that. Let's say there is such a situation, but you marry anyway. And for whatever reason, let's say they terminated your service record, which for schools is probably not as frequently, or maybe never it happens, but it will very well may happen if you hold a J1 status of some sort. What are you going to do? Do you need to leave? Do you have a chance of getting a green card? Well, I would submit to you that under current laws, you still have a chance of getting a green card in the United States, even though your status, that non-immigrant status, was terminated. Why? Because of that specific provision in the law. I mean, violation of the contract that you have with your employer or your sponsor is a separate issue from how the immigration law is going to treat the situation, and you need to remember that. In certain situations, it might be a close-cut case if you have an employment contract and you were sponsored by your employer and you don't have any backup plans. But most often, prohibition on marriage will not affect your immigration rights, I would say. So that's important to know, because I do have those inquiries. People say, oh, can I get married? Marriage is a civil act. It's not an act of immigration law, unless it's, let's say you marry somebody and you marry them right after you enter the United States, and now your intent of coming to the United States is at issue. All right, so that's important. You can read more about various subtopics of immigration law on our website, www.shevtsova.com. Thank you.